Okay, then we will go on the record. It is 11 o'clock, right on the button. This is the hearing for Clatsop County case file 22-000318, which is a request by the applicant for a variance to a side yard setback in the Arch Cape Rural Community Residential Zone. As proposed, the variance would reduce the side yard setback from 10 feet to 4 feet. My name is Tommy Brooks, and I'm the hearings officer presiding over this hearing. Before we begin, I'm going to say a few words about the format. We are conducting this hearing using audio and video conferencing with all participants appearing separately from remote locations. We will still follow the normal hearing procedures, and I will provide sufficient opportunity for everyone to participate at the appropriate time. It is possible that I may have audio or video issues. If that happens, please be patient. I'll just call back in. And you will be called on individually to begin your comments. So please wait until you are called on before you unmute yourself and speak. As you begin your comments, please state your name and address for the record. My role as the hearings officer is to approve, conditionally approve, or deny the application. All participants are allowed to provide new facts and arguments during live testimony. If you have prepared written comments, please provide those to staff before the close of the hearing so that they can be included in the record. In rendering my decision, I will consider only the factual evidence that is in the record. I will apply those facts to the applicable criteria contained in any provisions of the county's comprehensive plan and land use regulations that apply. The applicable criteria were identified in the public notice that announced this hearing. They are also set forth in the staff report. The county's code requires that I state the substantive criteria at the beginning of the hearing, and so those are as follows: section 2.8000, which are the variance standards, and 4.0600 Arch Cape Rural Community Residential Zone. Other criteria that may have a bearing on the decision, as I said, are listed in the staff report. It is imperative that you direct all of your testimony only to the applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to also explain why the criterion must apply so that others can respond and so that I can address that criterion in my decision. Failure to raise an issue with enough detail that enables me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to a proposed condition of approval with enough detail that allows me to respond to that issue in my decision precludes action for damages in circuit court. As I just noted, I serve as the county's hearings officer. While I have a contract with the county to serve in that role, I am obligated to remain impartial. To that end, I'll go on the record to state that I do not know the applicant. I have not visited the site, and I also do not have any ex parte contacts to declare. I'm going to go over the order of the hearing. I don't anticipate setting time limits for participation. It does look like we have a lot of people that want to participate today. If it starts to get long, I may establish some time limits. In order to avoid that, I would ask everyone to keep their comments tight and, again, to the criteria, the things that will matter in the decision. And I've read through the application and all the other materials that are in the record, so I have a good sense of what people's positions are, but it's really critical for the hearing to address the criteria. So the order we're going to follow is first have a report from staff. The applicant will then present the application. We're going to follow that by anyone who is here to give testimony in favor of the application other than the applicant. Follow that by anyone who's here to oppose the application. I will then give the applicant an opportunity for rebuttal, and then may have questions or comments from staff after that time. So before we begin, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter? All right, not hearing or seeing any objections. I'm going to turn it over to county staff to deliver the staff report.
Thank you, Mr. Brooks. I'm Ian Sisson, Senior Planner with the Community Development Department. I will share my screen with everyone here to give an overview of the application and the staff recommendation. Let's see. Okay, so as the hearings officer introduced, this is variance application 22-000318 by JJG or LLC. There was a neighborhood meeting hosted by the applicant on April 23rd of this year. Then the application was submitted on June 1st, deemed incomplete by staff July 1st, and then a revised application was submitted and deemed complete on September 26th. And so the record includes the initial application as well as the revised application materials. The subject property is 80486 Carnahan Road, which is improved with an existing dwelling that was constructed in 1930, according to the county assessor. And it's located in the Arch Cape Rural Community Residential Zone, AC-RCR, as well as the flood hazard overlay and the geologic hazards overlay, which are shown here. And you can see the flood hazard overlay covers the majority of the property. My calculation was 99.5% of the lot area. The lot area is 13,500 square feet roughly, according to the county assessor records. This is disputed by the applicant in the application based on their surveyor's boundary survey of the property, which showed the western extent of the property as the vegetation line, which would have resulted in a lot area of just under 6,000 square feet, which would be substandard for the AC-RCR zone minimum lot size of 7,500 square feet. However, as is explained in the staff report, the deed actually shows the western boundary of the property as the high tide line. And when staff requested additional information from the applicant, perhaps a revised survey, none was provided. So the best information available to staff is the 13,500 square foot lot size that we have based on assessor data, and staff did confirm with the assessor's office that they used the legal description of the property to determine that square footage. The reason this is important, especially with this application, is that for substandard sized properties in this zone, a reduced side yard setback is available. So the standard side yard setback is 10 feet, but for substandard lots that were legally created prior to 1980, that side yard setback can be reduced to 5 feet. So this lot is significantly narrower than the minimum lot size or lot width rather for the AC-RCR zone. So it is substandard by 16 feet. It's also narrower than the average oceanfront lot on Carnahan Road by a little over 20%. Another unique item with this property is that there is a 6-foot public pathway separating this lot from the adjacent lot to the north. We would typically see that as an easement, but this pathway appears to have been dedicated to the public at some point in time. The original deed for the property, or the oldest deed that we could find anyway, was from 1948, and that deed shows the property being 44 feet wide. So the proposal is to replace the existing dwelling on the property with a new dwelling that is designed around the flood and geologic hazards that are present. So there's the FEMA velocity zone as well as the AE 100-year floodplain. And so the applicant wishes to replace the existing dwelling with a new one that is built to withstand those natural hazards that are present. And so the new dwelling would be about the same square footage. It would be an increase of 29 square feet. And one of the major changes would be that the dwelling would be limited to a single story based on the requirements for the flood zone to elevate the first floor of the house above the base flood elevation, and then the building height limit for the zone of 18 feet. So in order to get a dwelling of a similar size with the same number of bedrooms, the applicant has proposed a building width of 29 feet 8 inches, which would require a variance to at least one of the side yard setback requirements. And so they have positioned the building 4 feet from the north property line. And one reason they're using to justify their variance request is that the 6-foot public pathway plus the 4-foot setback to their north property line would result in a separation of 10 feet from the neighbor's south property line on tax lot 800. So the variance criteria are detailed in the staff report, and the full staff findings are available there. But to go over those, the property needs to have exceptional circumstances that apply to the property that don't generally apply to other properties in the area, and that strict application of the zoning code would deprive the applicant of reasonable use of the land. So as we discussed, the property is significantly narrower than the average oceanfront lot in the neighborhood. It's constrained by the oceanfront setback, the 18-foot building height limit, as well as the flood and geologic hazards. And the flood hazard covers almost the entire lot and in a greater proportion than most of the other oceanfront lots on Carnahan Road. Again, the 6-foot public pathway would more commonly be established as an easement and would not require a setback. And as the applicant has argued, the strict application of the LADET criteria would not allow for reasonable use of the land, and staff evaluated reasonable use of the land as or by looking at other oceanfront development on the same road. And so again, the average width on the road is significantly wider than the subject property, and would allow for a dwelling envelope that would be 30 feet wide or larger based on the average and median lot sizes on the oceanfront on Carnahan Road. And the dwelling being limited to 24 feet on the subject property by following those 10-foot side yard setbacks would result in a width that's 22 to 30% smaller than what would be allowed on a more normal sized lot. The second criterion is that the granting of the variance is not injurious to the neighborhood or public welfare or safety. And so staff has found that the purpose of side yard setbacks is generally to provide for public health, safety, and welfare, as well as the health, safety, and welfare of the inhabitants of structures that are adjacent to each other, and that the 4-foot setback plus the 6-foot walking path would preserve the intent of those setback requirements. Some of the neighbors have brought up the fact that there is an existing view corridor to the ocean, which is pretty expansive when you compare that to the rest of the neighborhood, and those residents have enjoyed the vantage from their private properties. And staff has found that view corridors between buildings are not a right that is entitled by the code, and is not aware of any other legal protection such as an easement for that view corridor. And the conclusion on this criterion is that the 10-foot distance from the neighbor's south property line meets the intent of the LADET criteria. It's consistent with the rest of the neighborhood, the development pattern, and it allows for the applicant's reasonable use of the land. So I wanted to pause here and show some context photos on this note. And so here I've got an aerial photo with an arrow indicating the subject property. And you can see that the dwelling is quite narrow compared to most of the other dwellings on the ocean side of Carnahan Road. And here is a photo of that view corridor, including the 6-foot beach access. And then moving southward down Carnahan Road, I've taken photos of the view corridors between, or the space between, the other dwellings on the street. So I'll just flip through those so you get a sense of the streetscape here. And as you can see, many of these areas are narrower than what is present on the north side of the subject property. And also many of them, or most of them, include obstructions like trees or other vegetation or fencing. So the point here is to illustrate that a view corridor is not necessarily common, or the type of view corridor that's present on this property is not commonplace in the rest of the neighborhood. And one more time back to the subject property for reference. The third criterion is that the granting of the variance will not confer a special privilege to the applicant. And again, the ACR-CR zone permits single-family dwellings under a type 1 procedure, and no special privilege is conferred by allowing that use on a legally buildable lot. The next criterion requires proof of significant hardship if the variance is not granted. And again, the applicant has requested to reconstruct this dwelling to comply with the current FEMA codes and geologic hazard requirements. The current dwelling is not designed around those requirements or hazards, and the applicant has said this necessitates the replacement of the dwelling. According to the applicant, the architectural design of a reasonable replacement dwelling that meets all LADUT criteria would be unreasonably difficult. And this criterion also requires that the hardship cannot be self-imposed or self-created. And staff has found that the hardship was created by the exceptionally narrow lot width, the unusual configuration of the public pathway, and the proportion of the lot that's affected by natural hazards. And these are not items that are within the applicant's control, so the hardship was not self-imposed. The next criterion is that the granting of a variance is necessary for the reasonable use of the land, and that the variance request is the minimum necessary. So staff again has found that reasonable use of the land can be determined by looking at the existing development pattern in the neighborhood. And I've got the information about the lot width and dwelling sizes here on the screen. And the proposed 29 feet 8 inch wide dwelling with 1,700 square feet would be reasonable based on the neighborhood context. And in order to accomplish that building width on the 44-foot lot, the 6-foot variance would be the minimum necessary to accommodate that. And finally, staff is not aware of any violations on the property, and the owner does not own any adjacent land, and so that satisfies criteria F and G. And in conclusion, the request satisfies all of the variance requirements and is able to satisfy all of the other LADUT criteria with the conditions of approval that are recommended in the staff report. And I'm happy to answer any questions you have.
All right, thank you for that presentation. I do not have questions for staff at the moment. I may towards the end, depending on what issues are raised during the hearing. That's it for now. So with that, I think we can let the applicant present the application.
All right, thank you very much, Mr. Brooks. My name is Christian Zupancic, and address is 615 Broadway Street in Seaside, Oregon, 97138. And here on behalf of JJG Orr LLC and Jason Geis, the property owner. And I've got a quick presentation here, which I'm going to try not to duplicate any of the things that were raised in the staff report. So let me see if I can do that here. Okay, is that visible, that screen?
Yes, I can see that. Thank you.
Okay, so I'm going to probably brush through some of these because it's already been pointed out exactly where this property is at. So there's the property. The purpose of this variance, of course, is to reduce the north yard setback from 10 to 4 feet. And Primarily, it's due to geologic hazard conditions and this 6-foot walking path. So there were some previous variances in this particular neighborhood. Just as a background, Binkley and Holzer, a setback for 5-yard on side yards for an eaves overhang, that was in 2018. And then an 805.023 Carnahan Road, that was for saying a 17-foot variance to a 20-foot front yard setback. Same idea, geologic hazard conditions. So there's some background on other variances. The purpose of this variance really is, as mentioned in that staff report, to mitigate the impact of a substandard width lot. A lot of it has to do with that 6-foot walking path, and we'll talk about that here in just a second. The standard lot in the ACRCR zone is 60 feet. That's the minimum. There's also the effects of the velocity zone and the AE flood zone. These are special flood zones. And as staff found, it's 99.5 or 99.6% of the subject properties in those flood hazard overlays. So we've got lot size and shape, which is 44 feet wide. Vegetation does appear at about 5,800 square feet. Mr. Sisson did raise the issue about the entire lot area, and we did get a subsequent survey after that, but I did not submit it. And the reason is because it didn't come in at 13,500 feet, but it still came in over 7,500 feet. It was in between those two. So for the purposes of this application, it didn't necessarily matter. It was somewhere in between there because of the mean high tide line. So for the purposes of setbacks, didn't necessarily matter. So I'm going to leave that to the side for the moment. All right, so this gives you kind of an idea of how much of the property is in the velocity zone and the AE zone, which is the general flood hazard zone. The velocity zone, that's right here, if you can see my cursor. That VE zone, that's the one really that necessitates some very special building requirements on this. And I'll give you an example. So it requires essentially that the house get pushed up on these piers to allow for the ability to withstand wave movements. And because you have that 18-foot height restriction for oceanfront properties, you get 18-foot height, you get a restricted height on top, you get a pushed up foundation from the bottom, you get kind of a sandwich effect. And you can see that in this cross-section cut here where it's built up on piers. It's also kind of smushed down from the top. So you do get a pretty restricted kind of a building envelope, especially because of that velocity zone. We talked a little bit about the uniqueness of the lot, or Mr. Sisson did. A lot of it has to do with the lot shape and size. There's some examples here that were not originally included with the application, but for example, there is a case, a LUBA case out there, Neal versus Columbia County. This is 74 or LUBA 442 from 2016 on page 14. There was a high voltage line that effectively divided the applicant's property into thirds, and that created a unique property because there was no other lot that was similarly divided, and that justified the variance. Here we have the subject property, same idea, 6-foot walking path that got cut out of the property. It's the same principle. No other lot in the area has that same kind of configuration. So it's the same kind of idea where you have an unusual configuration, which would justify the variance. So again, most lots are going to be 50 foot or more on the ocean side. The subject property is really the only one that has this extremely narrow width. And you can see here, it's a little bit small, so you might not be able to make out all of these properties and some of the building distances from their property lines, but many of these buildings are going to be 30 plus or in excess of 30 feet as far as width. Some of these are already have very skinny corridors between them and their neighboring property line already. So it can be tight, but I'll show you the subject property here. And again, this was illustrated in the staff presentation. This particular diagram is showing you the house to be constructed. You have the neighbor's north property line up here, the south property line here, and then this is the walking path. This red circle here, I'm just going to blow up in the next slide. This is just a very simple illustration of exactly what's happening. The house would be 4 feet from the technical subject property line. There's 6 feet on the walking path. The overall effect is that you get 10 feet from the neighbor's property line, which is absolutely consistent with the intent of the code. And we will get to that just in a little bit, but what you have is a setback, or I'm sorry, the walking path, which is acting as, for all practical purposes, an effective setback all by itself. So I'll talk about kind of the general purpose of a setback, which was outlined in staff report. It really is for light and air between buildings, to benefit the inhabitants of those buildings, fire access, emergency services, utility lines, trees, and landscaping. So basically, it has a lot to do with your neighbors. And we've got a northern neighbor and a southern neighbor here. The southern neighbor, I understand, has submitted some objections, but there's no variance requested on that side. So there really is no effect on the south side. The northern neighbor does not necessarily support or object to it. But again, there's really no effect anyway, because the proposed building will be 10 feet from that neighbor's property line, which is in keeping with the intent of the ordinance. And as Mr. Sisson had outlined, the setbacks are not specifically designed for view corridors. Some of the neighbors really, they noted, and I paid attention to that comment, that 18-foot height restriction, that is special for oceanfront properties. The properties on the other side either have 20, I'm not sure exactly what their height restriction is, but it's significantly higher. So really that height restriction may be the thing that actually provides view, that was set in place to provide view, but setbacks, not necessarily so. You want to, the standard again is really up in that primary paragraph. So again, I just restated that general purpose for setbacks, and to point to the staff report, the staff report shows that when you combine that 4-foot setback with the 6-foot public pathway, you get a 10-foot setback from tax law 800. I want to talk about the reasonable use of the property very quickly. The staff report outlines some of this stuff in detail. Average size of the home on Carnahan Road is 1,983 square feet. The median size is 1,796. The proposed home on the property is going to be less than both of those, 1,700 approximately. And as the staff report concludes, it's generally consistent with the size of all the dwellings in the vicinity, and would therefore constitute a reasonable use of the land. So I understand that there's some neighbor objections, and a preliminary comment is that a lot of these objections are submitted in multiple form. A lot of it, there's same property owners submitting multiple comments or in different formats. So there are a few neighbors that again have submitted 1, 2, maybe 3 comments. As I understand it too, there are other neighbors who either support this variance or do not oppose it, but may have been afraid to speak up because sometimes these things are not popular in the neighborhood, and especially in face of vocal opposition. So that's just a preliminary comment, but I want to address these comments because in effect, we really are trying to be sensitive to neighbor concerns. As staff had mentioned, we did have a neighborhood meeting and we really did genuinely listen to the concerns of neighbors. There is some items in the additional materials that we submitted. Some of the neighbors had talked about, what would be the maximum width of a home just on your average lot out there? And the answer really was 30 feet. So we redesigned the entire house and we got it under 30 feet because we just want to be fair about this entire approach to this variance request. And really that is the crux of, or at least the main theme that I want to present here, is that we really do want to be fair. We don't want to ask for more than anybody else gets, but also just want to have the same sort of standard that anybody else would be subject to. So as far as reasonable use goes, we have some comments that say we shouldn't have considered all the homes in the Carnahan area. They would suggest using a comparison of single-story homes only, lots less than 60 feet, and oceanfront only. I just think that that is a very arbitrary and selective data set. There was a very comprehensive data set that was provided in the staff report. I think what you can't necessarily just sort of cherry pick your data points. It skews the data really to fit a presupposed conclusion. And overall, let's just get back to the standard. You know, in section 2.8010(3)A, you're applying these general conditions relative to other properties in the same zone or vicinity, not identical properties. You have to have a fair assessment and include a consideration of all properties. I also noticed that there wasn't necessarily a data set or an analysis provided in some of the neighbor comments that would help support some of those conclusions and their numbers versus the comprehensive data set that we got from the staff report. So again, you know, here are some of these bullet points down below. The proposed home is below both the median and the average size of the home on Carnahan Road. And one other point that I think is important, the criteria, the standard talks about reasonable use in general. It's not necessarily a reasonable home or reasonable structure, anything like that. We're talking about a reasonable use. And when you view this in context of the fact that the proposed home is going to be 10 feet from the neighbor's property line, the question is that a reasonable use of, or is that reasonable to construct a structure 10 feet from the line? And the answer is yes, of course, because that is the intent of the code. Another objection that came, this is one of the other themes that I pulled from a lot of the objections, and I really did read these objections thoroughly because I do feel like they're important and I want to address them. One of the objections was that the hardship was self-imposed, and the general sentiment was, well, it's self-imposed because the applicant bought the lot. That's not the applicable standard. The standard, again, is in 3A of this section. It's circumstances that result from a lot size or a shape that was in existence prior to the 1980 land use laws, and over which the applicant has no control. So this lot was created prior to the 1980 land use laws, and the applicant doesn't have any control over flood hazards or the public walking path or anything like that. So it was not self-imposed. And for some background on this particular issue, as far as the self-imposed standard, there's a case out there from Luba, Grant versus the City of Depot Bay, that's 53 or Luba 214 in 2007, on pages 12 to 13. The hardship not being self-imposed, that does not mean that the applicant just could have bought a different lot to accommodate the proposed development. If you read through that case a little bit, it makes the point that if that was the standard we were going to adopt, that there really probably wouldn't be any variances approved ever. In fact, the entire idea of a variance would be moot. And one of the other objections, one of the final remaining ones, was of course that view corridor, but again, that's not the general purpose of the setback. And even if it were the general purpose of a setback, there's really no change to an allowable view corridor because you still get 10 foot of space to the neighbor's property line. That is still maintained. So I mentioned before that one of the things that is the most important about this application is intent. When you look at the guiding principle behind a variance, it appears in section 2.8010 sub 2. The intent of the variance generally is to overcome the practical difficulty to development and preventing the owner from using the property as intended by the zoning ordinance based on these unusual lot conditions. So the intent of the zoning ordinance regarding setbacks, it's to provide space between neighboring structures, which is perfectly preserved here because we have our 10 foot of space between the proposed house and the neighboring property line. So I think that's really important to keep in mind is what is it that we're trying to achieve with this variance? Well, it's to basically maintain the intent of the zoning ordinance, which is exactly how we designed the footprint of the house and this approach to this variance. So the approval conditions were listed out on the last page of the staff report, and the applicant would agree to all those proposed conditions, including those conditions that have to do with view and aesthetics, because again, we are trying to not only be fair, but to be sensitive to neighbor concerns. Condition number 4 is to maintain vegetation at a height that's no greater than 6 feet, which the applicant would be fine with doing, happy to do. There's also condition 3 that talks about exterior lighting with a full cutoff design directed away from neighboring property. Happy to do that as well. So there are some conditions in there that that do take in some neighbor concerns, and we're happy to satisfy those. So the conclusion here is that we do meet all the applicable criteria for the variance. There's the uniqueness of the property, exceptional circumstances, reasonable use of the land, and that we'd recommend approval with conditions. And I'm also happy to answer questions as well. Thank you.
All right, thank you. Mr. Zupanchik, are you the only one that's going to be presenting on behalf of the applicant, or are there others?
I am, yes, except there may be others who participate after, at the end, if there's a rebuttal period. So there may be other folks involved, but
okay,
the initial presentation will just be me. Yeah.
Okay. I do have a few questions for you then. One, I just want to make sure I'm understanding kind of whether and how we've resolved the square footage of the lot. It sounds like the actual number might be in dispute, but the applicant's not disputing whether or not you're within that threshold. So the conclusions in the staff recommendation are still sound, or can you, I guess, just clarify your position on what the lot size is?
Correct. We did do a survey of the property, and I believe it came in a little over 9,000 when measured to the ordinary high tide line,
okay.
not 13,500. Again, that mean high tide line is something that a surveyor has to go out and find. And in many cases, some of the county lot maps just sort of extend the property out as far as it will go towards the ocean. When you actually get down on the ground, it's not 13,500, but it's also over 7,500. So for the purposes of what we're doing, I would agree with staff that it is over that 7,500 mark. Yes.
All right. Thank you for clarifying that.
Sure.
My other, I guess I have kind of 2 lines of questioning, and they're kind of related. And it really has to do with, in order to, I think, get through this analysis, we have to understand what impact a strict application of the zoning ordinance would mean. And in the application, there was a statement that, the minimum width that you could build to and still be reasonable would be 33 feet. That was later revised down to the 29.8. So it seems like there is some, I guess, wiggle room from a pure engineering architectural standpoint. I guess, do you have a position on what the minimum really is? I mean, is it 29.8? Is it something less? What is the narrowest that could be built and still be reasonable?
The narrowest, and I can say this just from having gone through the various revisions to this plan with Mr. Geis and with our architect, Jay from Tolemana Architects, Jay Orloff. We had this configuration set up, and it's a pretty compact little footprint. And we held the neighborhood meeting, and folks said, hey, 30 feet would be the maximum width. So given that, we basically just shaved everything we possibly could off the design of the house. So eliminated a lot of closets from the bedrooms. Some of those are basically just going to be armoires, narrower hallways, narrower, I believe, possibly smaller bathrooms, and reductions of kind of side porches and things like that. So it was definitely a squeeze. So yes, I still believe that this is kind of the minimum that we need in order to really get reasonable use of the property. And again, the standard there is, as applied, what would be the reasonable use of the property? And that reasonable use would be essentially, as far as what the ordinance has determined, is that you get a property that's essentially 10 feet from your neighbor's property line. So when you consider that, it's not just about the total area the footprint that comes into play, but also distance from neighboring structures. But again, to answer your question, we did have to do some pretty tight squeezing in order to fit that footprint within a 30-foot width. And we gave up as much as we could really as far as living space, but that was kind of the max of where we arrived.
Okay, thank you. Sort of along those same lines, and this may be the harder question, but I think looking at the county's code, let's just say for the sake of argument, I accept the uniqueness of the property, sort of the lack of injury, if and I understand the interplay of the public easement along the north side, but a lot of the discussion is about sort of that the proposed development is reasonable, and I wonder if that is what the standard is, because the section E of that same code section says granting the variance is necessary for the reasonable use of the land, and that the do I have the right language here? I guess a way to analyze that would be that a strict application of the code would only result in unreasonable development. And that was reflected in one of the comments that was submitted to the record, which was, it doesn't really matter how reasonable this proposal is, it matters whether or not the alternatives are unreasonable. And I wonder if you can speak to that, of why without the ordinance, a resulting house or a resulting structure would be an unreasonable development.
Sure. A lot of that really is just the standard that's been established in the neighborhood and the entire character of the neighborhood. So that's a lot of what the staff report did. For example, it compared what would normally be the allowed width of this property without this variance, and then compare that to what exists on the street. So when we talk about that word reasonable, it's definitely a subjective term, obviously, and it can also be objective. And from a subjective standpoint, a lot of folks are going to disagree about what's reasonable. From an objective standpoint, you really have to look at what the character of the neighborhood shows us and the size of the other buildings that are on the lot, the size of the other lots. And that really is probably the best that we can use in order to establish that standard from an objective standpoint. So again, it's difficult because we are going to disagree about what what's a usable house and what isn't a usable house. So we're really trying to measure ourselves up against what other folks are doing in the neighborhood, and to use that generally as the standard. There's also the issue too of, if you have a 24-foot house, you're going to be restricted to maybe 1 or 2 bedrooms. And again, the character of this neighborhood really is that there are a lot of beach vacation homes in this neighborhood. That's essentially what this neighborhood is all about. People bring their families here. They use this in the summertime. They come and enjoy it with extended family. And it's the same purpose for which Mr. Geis and JJJ Orr wants to use this property, is for family gatherings. It's been the way that it's been used for years. When you start to restrict the property down to 1 or 2 bedrooms, there just isn't enough space for that kind of use, especially as you consider it with the general character of the neighborhood. So, when I see 1 or 2 bedroom type houses, those generally get turned into, for example, short-term rentals. I'm in Seaside here, so I see plenty of those. And I know that in Seaside, that's kind of the flavor of how things go. There's definitely a glut of short-term rentals. That's not necessarily the case down here in Arch Cape. It's very much a family gathering type of neighborhood. And to do that, you have to have enough bedrooms, enough space for a family, an extended family to gather. So that's the kind of thing where I would say it is reasonable to have the kind of home that is similar to other folks' homes, and especially what they're allowed to build, because that would be in keeping with the character of the neighborhood.
All right, thank you for answering that question. I don't have anything else for you, so we will move on to the sort of the next group of testimony.
Sure.
This will be the part where anyone who is signed up for testimony and is going to support the application other than the applicant. And Ian, I don't know if anyone signed up with that kind of detail, if you know, or if we just need to ask for a show of hands if there are any.
I think the only folks that I had pre-register were opposed. I did hear from Rich Sharon, who I see here, and I'm not sure if he wanted to speak, but I did get an email from him this morning. So he would be the only person I think that I'm aware of.
Mr. Sharon, is your intent to testify in support? And you're muted. I'll need you to unmute.
Are we there?
I can hear you.
Okay. Yeah. First of all, everybody that lives on Carnahan Street is probably.
Mr. Sharon, sorry, are you going to testify in support of the application?
Yes.
Okay, and then could you begin by stating your name and address, please?
Rich Sharon, 80457 Carnahan.
Thank you.
And like I said, first of all, everybody that lives on Carnahan Street has probably used this beach access on the north side of the lot, and we've used it for the last 40 years, which is how long we've been down there in Arch Cape. And we support this variance request for the property located, which we're discussing. Like I said, we've lived there for 40 years and come to know and love the history and ambience of this neighborhood. You know, the house is currently on the lot was built a long time ago. It's a neighborhood eyesore. Needs to be updated to comply with FEMA regulations and guide zones, which has been discussed. It seems like this would make safer for the inhabitants of the new house, as well as the surrounding homes, acting as a breakwater for any type of surge that would occur. So it'd be a safer environment for the people that lived around there. You know, and I can talk about the 6-foot walking path, but that's been discussed. But it's used by most everybody that resides non-ocean front in the north part of Carnahan Road. And, you know, the applicant's house will conform to the existing neighborhood setback requirements, which has been discussed. You know, and I think he's sensitive, the applicant is sensitive to the neighborhood because they have cut the size of the home down from the size that it was to try to conform and keep things as narrow as possible. But you know, I do believe that this variance is keeping in with the spirit of the Carnahan neighborhood that we've come to know and enjoy for these many decades, and we do support this variance.
All right, thank you.
Yeah.
I'll just ask one more time for the group if there's anyone that is here today to testify in support of the application. If you could either raise your hand or speak up. Looks like Betsy Reed.
I'll let Gian go. I'm in support of the variance 100% for all the reasons outlaid today by Christian and the folks, Rich. So sharing the sentiment on, you know, the reasonable request and the safety, and also just the, you know, the upkeep of the neighborhood and making another beautiful home for our family to enjoy and be able to share in. And that's what this is. And I know it's been said before, but it's a family home. It's not a vacation home. It's a place where we really hope to continue the legacy that's been established by, you know, the family, Rich and Joni and everybody, to enjoy and continue to create memories in Carnahan Road. And that's the purpose. That's the spirit. and that's what's in our hearts. And so, we do want to stay objective and look at the facts, and that also is our charge. But at the same time, clearly there are emotions that come along with this too. So fully supporting the variance, and look forward to being able to move forward and create a beautiful home to add to the community.
Ms. Reed, would you mind stating your address for the record so that we can keep track of who gave testimony?
My personal address.
Wherever you would like to receive notice of a decision.
Okay. Do I need to say that on a call with 30 people?
You don't have to, but I'll just warn you, it means you would not receive notice of the decision. And so I would prefer if you would like to provide that later to the county. I'm okay with that. I just
I'll email it to Ian. I'm on threads with folks, so if you don't mind.
Okay, please do that before the close of the hearing, which will likely be today.
Yeah, absolutely, no problem.
Thank you.
Thank you.
I believe I saw one other hand. Someone is Tina Deal, and you are muted, so I need you to unmute your Zoom first.
Are you talking to me?
Yes, it looked like you had raised your hand. Would you like to provide testimony in support of the application?
Yes, I'm Jan Geis, Jason's mother. Address is 3600 Northwest 107th Street in Vancouver, Washington, 98685.
You're in support of the variance.
Hmm?
You have to say you're in support of the variance.
I'm in support of this. We started coming down to Carnahan Street 40 some years ago and always stayed at my sister's house. That's Rich Sharon's house. Then the family grew too big for one house. So my son, Jason, decided to buy one for our family to enjoy. And he found the property. We've waited for over 6 years to get an okay to build this dream house. He's changed the design several times to accommodate the regulations and get the approval of the board and the neighborhood. Please give us your approval this time.
Thank you, Ms. Geis. Is there anyone else on the call who would like to speak in favor of the application? All right, I'm not seeing any, so we're going to go to the next set of testimony, which would be anyone who's here today to provide testimony in opposition to the application. And I will, if you could raise your hands, and I'll try to take you in an order and we get through everybody.
Mr. Brooks, did you want to start with the folks that pre-registered?
That's a great idea. Actually, does it appear that everyone is on the pre-registered?
I believe so. I can start. The first on my list was Bill Riley.
Okay, let's do that. Mr. Riley, I see you.
Yes, good morning. Thank you. My name is Bill Riley. We're opposed to the variance. My address is 312 2nd Street in Lake Oswego. My wife's family has owned 80487 Carnahan, which is the home directly across the street from the property in question, for over 55 years. Goes without saying that we love Arch Cape. My wife and her siblings spent countless weeks and months growing up there. Our children have grown up enjoying Arch Cape for over 35 years. We're looking forward to the next generation being able to enjoy it as well. We certainly understand Mr. Geis's desire to build a new home there, and we support him doing so, as long as it meets the very well-defined and very well-known zoning requirements of the area. The zoning restrictions were certainly not a surprise to the buyer when the property was purchased. We've reviewed the subject variance as well as the Clatsop County staff report and recommendations. We've submitted several detailed documents for your review, but I'd like to briefly summarize our issues with the variance application and the staff report. The report concludes that the requested variance is the minimum necessary for reasonable use of the land, that the hardship is not self-created, and that the variance would not result in substantial injury to the neighboring properties. We feel these are all erroneous conclusions. The county report states that a home of 1,392 square feet with 2 to 3 bedrooms could be built on the property without the variance. A home of this size is certainly a reasonable sized beach house and is consistent with the size of similar homes on similar sized lots on Carnahan Road. We feel the flaw in the staff report is that it uses a comparison to properties and homes on Carnahan Road that are not comparable to the property in question. The attorney for Mr. Geis talked about cherry picking the data. Well, the problem is that the data set analyzed by staff included some very large lots and 2-story homes that are no longer allowed on Carnahan Road. In reality, the staff makes no mention of these differerences and we believe misrepresents the comparison to houses along the road in the process. The reality is that there are 11 single level homes along the waterfront with lots narrower than 60 feet. There was a mention that we didn't submit a data set. I'd be happy to submit the data. I've got them summarized here. All of the addresses, the square footage, the number of bedrooms. The average area of these homes, or the average size of these homes, is a 2.8 bedroom, 1,375 square foot home that is actually smaller than what is allowed by code for the lot in question without the variance. The proposed home is over 1,700 square feet, nearly 25% larger than the average home on similar sized lots. Building a 1,400 square foot home is not an unreasonably small home for the area and certainly does not provide them of reasonable use and enjoyment of the property. In fact, online I found many examples of 3-bedroom, 24-foot wide, 1,300 to 1,400 square foot homes, single level, that would be appropriate on that property. The staff report also concludes that the hardship was not self-imposed. In reality, the hardship is clearly self-imposed. The zoning restrictions were well known to the party when the property was purchased. The applicant is attempting to maximize the number of bedrooms in the home, but the applicant can easily build a size-appropriate home that is consistent with the neighborhood. The comparison to the existing home is also irrelevant. The existing home has a garage that was converted to a bedroom, and the upstairs bedrooms have ceiling heights of barely over 6 feet. No reasonable person would have called the current house a standard 4-bedroom home. The fact that the home has gone unused for years clearly indicates that the bedrooms were and are substandard. Finally, the staff report states the variance would not impose an undue burden on the neighborhood. That's clearly not the case. The variance would result in a substantial reduction in the view corridors to the Pacific Ocean. That alone creates an undue burden on the surrounding homes and the Moore property in particular. The reduction in view corridors also would have an effect on permanently reducing property values of the homes impacted by the view reduction. In summary, we oppose the variance application and we believe that the staff report and recommendations are seriously flawed. We hope that you will reject the request to reduce the setbacks and deny the application for a variance.
Thank you, Mr. Riley. And just as a reminder, if there is information like the data set you mentioned that you want me to consider and you want it in the record, please provide it to county staff so that it's in the record, and that'll need to happen before we close the record.
Okay, when will the record be closed?
That is to be determined, but it could be as soon as the end of this hearing today.
Okay. I can submit it handwritten, but I'd like to type it up if I have a little time. So,
all right, I'll leave that up to you. Thank you.
All right, thank you.
All right, Ian, next on the list.
Bill Gordon.
Okay, can you hear me?
I can, Mr. Gordon. Thank you.
Okay, thank you. Yeah, good afternoon. My name is Bill Gordon. I'm testifying in opposition of the variance request. Mailing address is P.O. Box 449, Lake Oswego 97034. My wife and I built our home at 80493 Carnahan in 1982. We're east and slightly northeast of the applicant's property. We've known that at some point in time, the 80486 property would be sold, the existing house demoed, and a new house built. And we knew that part of our beach and oceanfront view or ocean view would be eliminated, but not like this. The applicant's proposed home will greatly reduce our view to his north side, and we're not alone. Other neighbors are affected too, particularly, as you just heard, the Moors to the south. The page 131 in the staff report shows this dramatic effect. Our view would be further compromised by the 18-foot flat roof with 2-foot overhangs. We've been told that this is much better than the current 20-foot roof, but this isn't true because the current roof or the current house has a sloped roof line. And for us, the entry stairs and protruding fireplace also will have an impact, with the stairs actually built right up to the property line. So we're harmed. Our ability to enjoy our 40-year-old home would be lessened, and its value may be reduced, and our neighbors too. Our shrunken view corridor is one thing, but as we wrote in our submitted letter and other letters that you've received, the applicant could and should build a well-designed, almost 1,400 square foot, 3-bedroom, 2-bath, 100% code compliant home on his narrow lot. This would be a perfectly reasonable use of the property, certainly in most people's minds. The applicant wants a bigger house. It's just that, a want, a desire. But to do that, the applicant also wants an unjustified 6-foot variance. More for him, while the neighbors have less. The applicant, and particularly the county staff, have tried to justify this variance request without regard to the neighborhood and also with ill-conceived size comparisons. The staff package also basically says that the other view corridors along Carnahan Road are severely compromised. So why not ours? Our letter and other letters submitted for the record have logically and rationally challenged these size comparisons and other comparisons. Clatsop County's land use hardship code exists for a very good reason. In this case, a number of the code's high required standards simply haven't been met. And as a result, this variance request should be denied. And I may add, in support of Bill Riley's analysis, that analysis can be very simply done. We're not asking you to do it, but can be very simply done by going to the last page of the exhibits. I think it's literally page 147 or 148, where there's a listing of every oceanfront house, address, construction date, size, lot size, bedrooms, and type. And as Bill Riley mentioned, that to include several of these obviously non-comparable, irrelevant sized homes that create the average that's been cited, average and median, makes no sense to us. For example, included in these averages are 2 homes that are physically not located actually on Carnahan Road itself. And they're the last 2 shown, with the combined square footage of those 2 homes alone at about 8,000 square feet. So anyway, Bill Riley is going to be submitting the detail, but we definitely believe that the comparison cited by the applicant and his representative are flawed. Thank you. Appreciate it.
Thank you, Mr. Gordon. Ian, next one.
Carrie Lesher.
Ms. Lesher, you are muted.
Thank you. Yes, my name is Carrie Lesher, and I am the granddaughter of the builder of the house just to the south of the applicant's property. That is 80484. My primary residence is in Portland, Oregon, 7025 Southeast 16th Avenue. And I am testifying to reject the applicant's variance request. In addition to the reasons set forth by previous people who have been testifying today against the variance request, I want to address specifically the definition of reasonable use of the property. Our home was built in 1949 by my grandfather. It's got 2 bedrooms. I've been visiting this home since I was 6 weeks old. Our family has had countless family gatherings in this house with 2 bedrooms. The applicant claims that he needs a bigger house, but his claim of reasonable use, as well as his claim of hardship, is totally self-created. The width of the lot did not create a hardship for the applicant. The applicant created any presumed hardship for himself by purchasing a property whose restrictions he was well aware of prior to the purchase. That's all I have to say. Thank you.
Thank you, Ms. Lesher.
We had Christina Knight. I saw her earlier, but don't see her at the moment. Christina Knight.
Christina
Christina,
Knight. Go ahead, Tom.
Christina wasn't feeling well and had to drop. Yeah, sorry.
Okay, thank you. Tom Moore.
Yes. Let me know. I assume you can hear me since you just heard my response. This is Tom Moore. My home address is 6530 155th Avenue Southeast in Bellevue, Washington. I'm the co-trustee of the house across the street, 80487 Carnahan Road, directly across from the subject property. And as Bill Riley mentioned, our family has owned that house for over 55 years and has enjoyed our time with family and friends on Carnahan Road. I don't want to repeat things. I could, but I'm not going to repeat things that have already been said. I am in opposition to the variance request. I just wanted to clarify a few points that were made. And one is that Bill and Bill mentioned that the data set that we used is the one provided by the county for our analysis. But as an example of some things that Bill Gordon said, one of the homes that is listed was built on 2 pieces of property that were purchased and joined. So it's much larger lot than normal, and a much larger house than you would expect. So we would generally exclude that from analysis. It's a 100-foot wide house. And one of the houses that's outside the gate, there's a gate as you approach our private street. But one of the 3 houses that's outside the gate that has a Carnahan address that was built in the early 80s. It was built on what was, I think, 7 lots were purchased and joined together. So it's a house that's built on 3 acres and is much larger than you would see on Carnahan, but it's included in the county's and the applicant's analysis. And so for those reasons, we think houses like that should be left out of the analysis, and we should concentrate on 1-story homes on the oceanfront, or even not on the oceanfront, just on Carnahan Road inside the gate. Another point is that on the oceanfront lots, if you exclude the lot where 2 lots were combined, 74% of the lots are less than 60 feet. So 74% of the lots are substandard. So it's not unnormal, it's not abnormal to have a lot that's less than 60 feet on the street, because of when the lots were laid out years ago. It's just the way that it is. So it's not substandard, it's normal for the street. In addition, the notion that if the house is built as suggested, 4 feet from the property line, with the additional 6 feet side yard setback to the north, the house to the north is 8 feet from the property line. So it wouldn't leave 20 feet between the 2 houses. It would leave simply 18 feet. So there is a constriction there. And then also some of the houses on the street that are less than 10-foot setback from their side yard property lines, were built, I assume they were all built before those rules went into effect. The regulations went into effect. So yes, it happens. Yes, that is the case. Yes, as houses are rebuilt, they need to adhere to current regulations, but we will find examples of older homes that are closer to the property lines than is required by regulations, and that's normal. The applicant or prior presenter indicated that a 1,400 square foot house would be limited to 1 to 2 bedrooms. I'm not a designer, but it seems clear to me that you should be able to easily fit 3 bedrooms into a 1,400 square foot house. And it might be possible with 4 bedrooms if the bedrooms were a bit smaller. So I just am wanting to say, I think we should be comparing to similar lots and similar other homes on Carnahan. And as Bill Riley mentioned, the 1,375 square feet average for those homes seems reasonable and would comprise reasonable use. And I already told you about the data sets. I think that might be all that I had.
All right. Thank you,
But
Mr.
I conclude by suggesting or recommending that you deny the variance. Thank you very much for your time and
Thank you.
The final person we had registered was Fritz Pryor. I don't see his name on the list, but just in case he's under another name, Fritz Pryor.
Okay, not seeing Fritz Pryor. All right, so that takes care of the folks who signed up in advance of the hearing to give testimony. So if there's others online who would like to speak in opposition to the application, just identify yourselves.
Can you hear me?
I can hear you.
Okay, I am Fritz Pryor. I don't know why my name isn't appearing there. Anyway, my name is Fritz Pryor, and I'm a family member of the Tabor clan just to the south at 80484 Carnahan Road. My address is 2008 Southeast 143rd, Portland, Oregon 97233. I'm in full support of those opposing the variance. In addressing the standards for a variance as to parts A and E, if the county is actually considering the standards fairly and accurately, a reasonable use of this property should be a home built within the parameters of the rules put in place for very good reasons. Granting this variance simply ignores those rules for the sake of one property owner's desires, and I believe sets the wrong precedent. That's, again, I fully support the opposition to this variance, and thank you for your time.
Thank you, Mr. Pryor. Is there anyone else who would like to give testimony today? Looks like Ms. Moore.
Yes, I would. I know. Yours. Can we do that? Can you shut up here?
Ms. Moore, is there another person in the same room?
Can you hear me now?
That's better.
That works. Thank you.
There we go. Can you hear me now?
Yes.
Okay, thank you. My name is Ann Moore. My mother-in-law, Mary Ellen Moore, has owned the home at 80487 Carnahan Road for over 50 years. And I've had the pleasure of coming to her home for the last 35 years. I'm opposed to the granting of the variance request. The granting of a variance under section 2.8 variance indicates that there must be a hardship that cannot be overcome. It's clear that a home that is 24 feet wide can be built on this property, and that house fits into the character of the neighborhood, and therefore there is no hardship that cannot be overcome. Any hardship that is claimed is self-created by the desire to have a home that is larger than would otherwise fit on the lot per the county code. The applicant knew he was buying a lot that was narrower than some of the other lots, although there are 2 other lots on the street that are even narrower. Now that he owns it and wants to build a large home, he is claiming a hardship because his lot is less wide than others. Clearly, he created his own hardship. And while the county says the hardship is not self-created or self-imposed, all elements described as a hardship were known to the applicant when he purchased the lot. If you were to grant this variance request, then you are conferring the special privilege of the use of the 6-foot public path as if it belongs to the Geist property in regard to the side yard setback. Well, clearly it does not now, nor has it ever been shown that it did belong to this lot. As of today, and from the beginning of this neighborhood, that 6-foot path has belonged to the entire community of Carnahan Road. All the paths that are along Carnahan Road add to the open and inviting nature of the neighborhood character. Granting this special privilege to this one property owner would be harmful to the overall neighborhood. Please deny the request for a variance, as the request has not met the very high bar that is required. Thank you.
Thank you, Ms. Moore. And is your address already in the record? Did you submit comments?
It is. My address is 6530 155th Avenue Southeast, Bellevue, Washington.
Thank you. Is there anyone else?
Actually,
Mr. Gordon, you've already given testimony, so let me work through everyone else and see if there's anyone else.
this isn't really in addition to my testimony. I happened to just print out Christina Knight's testimony that she was going to give. Can that be possibly entered?
Ms. Knight or anyone is allowed to submit stuff to the county for the written record.
Mr. Brooks, I did receive an email from Christina Knight during the hearing with a copy of her comments.
Okay.
So we'll get those entered for you.
Great, thank you. Anyone else who has not spoken that would like to speak in opposition to the application? Does not look like it, so I'm gonna turn it back over to the applicant and the applicant's representative for rebuttal.
Thanks, Mr. Brooks. Again, this is Christian Stupancic, speaking on behalf of the applicant. I wanted to address a few things that popped up during some of the opposition comments in rebuttal. First of all, there's no precedence that is set via the approval or denial of a variance. And I think that's been fairly well established that each property is unique, and that really is the crux of why we have variances. So this is not a precedential type of issue. The other thing that came up and I definitely heard was comments about the reasonable use of the property. And again, the reasonable use of the property, the best that we could do to really get an objective standard off of that is to compare the proposed house to the rest of the structures, the rest of the homes in the area. We can't really constrict that data set. There may be certain outliers, but by and large, you know, the exhibit and the list of data that's provided in the staff report is comprehensive, and I feel like is fair, because again, that standard is the same area or vicinity. It doesn't say the same street, just says the same area or vicinity. And so you have to have enough of a data set to really get a representative sample size. And you can't really do that by constricting that data set. And then as far as getting back to that standard, again, I wanted to go over exactly what that standard is, and that's section 2.8010, and that's sub 3A. The last sentence of that particular subsection says, these circumstances or conditions must be such that the strict application of the provisions of this ordinance would deprive the applicant of the reasonable use of the land and or structure. So it's not just the structure, it's the land. And when we talk about the reasonable use of the land, why is it not reasonable to situate a house that utilizes the buffer of a public walking path and still maintains a 10-foot setback from the neighbor's property line? That is a reasonable use of the land. It's the kind of use of the land that everybody else gets. They all get essentially 10 feet from their neighbor's property line. And when you view it with that particular standard, that's a reasonable use of the land. Regardless of how much we might disagree about how much space is actually needed for a family. And I've gone over again my reasons for saying that, a certain minimum area might be required. The more you constrict this, the less or the farther away you get from kind of the character of the neighborhood. And all of this really wraps up again in intent. Sometimes it's very useful to go back and just determine what is the intent of a variance. Look at that broader standard. And that broader intent is, again, or I should go back and say that section 2.8010 sub 2, it talks about the practical difficulty to development, preventing the owner from using the property, again, the property as intended by the zoning ordinance based on these unusual conditions. And the intent with, as far as setbacks in the zoning ordinance, is really just to preserve a buffer between neighbors and structures. So really, by configuring the house this way, we have been completely consistent with that intent. And that's why it constitutes a reasonable use. That is it. Thank you very much.
All right, thank you. That brings us to the end of all of the testimony. Ian, I'm going to ask if there's anything else staff needs to either comment on or bring to my attention before we potentially close the hearing.
I just want to say one thing quick. This is Jason Geis.
And Mr. Geis, you're the applicant?
Yeah.
Okay.
Is this the right time?
Yeah, you have your rebuttal opportunity.
Okay, thank you. I just want to start by, first of all, thanking Ian for being so diligent on this. There was a ton of work that went into this, and saw the back and forth. And so I just thought he was extremely thorough on this, and just want to say thank you, Ian. We've been going down there for a long time, and we just want to be a part of the neighborhood. And I don't want to restrict and tell my kids who can't go on the weekends. And so we tried to listen when we had the neighborhood meeting, and we shrunk the house, and we tried to take as much of that into consideration as possible to be a good neighbor. And Christian, correct me if I'm wrong, there's no impact to the south. So I'm a little bit surprised on the issue on the south. On the north, there's really no impact. They were neutral on it. And the viewways are not a right. So I'm just trying to stay pragmatic about it. A lot of these, we come down for a weekend or a couple weekends out of the month, and we're just trying to build a house big enough that I don't have to tell my kids like which ones can't come down when we're down there. So I'm just trying to stay pragmatic about it and focus on what Christian had talked about and what the rights are, and keep some of the emotion out of it. And I appreciate the thoroughness that Ian went through on putting all this stuff together. I appreciate that. Thanks, Ian.
And I'll follow up with that just a little bit. Is that as far as that north side, there really isn't any impact either on the northern neighbor because of that 10-foot space that's between them. And the intent of the setback, again, we've already talked about that, but there is no legal right to a view easement unless that has been specifically recorded in the property records. And I concur with staff that I haven't found anything like that in this particular area. There's no recorded view easement. Those things can be in place, and sometimes people do put them in place for these reasons. And that's because there is no default right for that. And the setbacks are not designed for that either. Probably the best that can be said are height restrictions, and we're not asking for any kind of variance to the height restriction. So that again, there really is no impact to the side properties, the northern and southern neighbors. And those are really who these setbacks are designed to benefit. So thank you.
No, and some of the pictures that Ian took, there's different trees and different things that really are impactful to the views. And I think in the spirit of us, again, being flexible, we're willing to put some things in the agreement as far as, no fences, not impacting those. If you look at some of the pictures, there's some big trees up where people couldn't even see through, if they wanted to. I really like the pictures that Ian put up, and in the spirit of this, we're willing to say these are the agreements to make sure that, you know, we try to respect what you guys are saying as much as possible.
Mr. Zupancic, does that conclude the applicant's rebuttal?
Yeah, thank you.
Yeah, Jay, do you have something else to say?
Yeah.
That Jay Orloff is our the architect who designed the house.
Hi, my name is Jay Orloff, representing Tovan Architects, PO Box 648 Cannon Beach, or I'm sorry, Telvana Park.
Mr. Orloff, you muted yourself accidentally.
There we go. I would like to address a few notes that have been brought up. One in regards to setbacks, as had been noted previously. I didn't mean to be redundant, but setbacks are designed for light, air, and for emergency services to control fire bridging. And it was brought up that there was impact into setbacks via the stairway and the fireplace. These are architectural elements that are allowed within the setbacks at their height as architectural elements. So these should not be issues that should be considered. In regards to the design of the house, we, in our redesign, we did narrow it considerably 4 feet, and those 4 feet meant no closets in 3 of the 4 bedrooms. They are now restricted to armoires. This is a simple design structure, double loaded bedrooms on each side with a single hallway down the middle. The hallway is 36 inches, again, narrow. And as for the size of the bedrooms are single beds with 36 inches clearance around them for gurneys or emergency purposes. This is a standard. Any further reduction in width of the design would result in the loss of a bedroom. Because of this, we are not allowed a second story where I would normally take up at least 2 of these bedrooms. Again, the 18-foot height restriction is for views from non-oceanfront properties, meaning the properties to the east, who quite a few of the 5 of the ones that have been applied or have shown resistance to are on that side of the property. So we are holding tight to our view corridor, which is above the houses, not between them, with our 18-foot restriction. And again, any further reduction in the size of the footprint, because we are limited to oceanfront setback as well. So our buildable area is roughly around 1 acre. If we take in consideration 80487 next door, they have 0.28 acres, more than double the size. Granted, it's not an oceanfront property, but that is a 4-bedroom, 2,351 square foot house. We would not be able to build this on this property due to the restrictions of height and buildable area from the oceanfront setback. At this point, any further reduction would not meet the needs of the family. And a lot of people have brought up what is the need of the family. The Geis's family do have different needs than neighboring properties. They will have a blended family, and it doesn't matter what their needs are. It is a buildable and is it a responsible size of a house for that need? And I feel that it is. And any further design constrictions would definitely impact the ability to use this for the Geis family. Thank you.
Is that it for the applicant's rebuttal?
I think so. I don't see anybody else here. I'm just going to run through real quick. I believe so, yeah. Thank you.
Okay, thank you. All right, then I'm going to close that part of the hearing and turn it back over to staff just to see if there's any other comments or things that need to be brought to my attention before we decide what the next steps are.
Thank you, Mr. Brooks. Just for the record, I did receive email from Bill Riley with the property size information that he mentioned in his comments. And I also removed, for the sake of just checking, removed the 2 dwellings at 80392 and 80390 Carnahan, which are on the south side of the gate. As some of the commenters had said, those should not be included in the data set because they're They're not in the same part of the neighborhood. And they were, very large and on larger lots. So after removing those from the data set, the average oceanfront dwelling size was still just over 1,800 square feet, and the median was 1,763. So just for the record, and of course you have the full data set available to you if you want it in electronic format. So you can toy around with it. I'm happy to provide that to you.
Okay, thank you for that clarification. That when we're speaking to that, that is the page 148 in the packet.
Let me double check that. That's correct. I have, that's the one I was just referring to, is page 148, and then I have the data on 147 and 148 in an Excel format if you'd like a copy.
Okay, I'm not going to ask for that native format. I think it's sufficiently in the record for me to be able to review, but thank you. All right, well, that concludes the hearing for today. I'm going to close the record and the hearing. The time is 12:30, and I will take this matter under advisement. Thanks.
Thank you.
Thank you.